Stock options and divorce in Illinois. Stock options seem like sophisticated financial instrument for the rich and about to be rich, and they kind of are. The problem with sophisticated financial instruments, like stock options, is that they are hard to divide in an Illinois divorce. So, how do you divide stock options in an Illinois divorce? What are stock options? There are two classes of options that people refer to when they say stock option. One type of stock option is a sophisticated way to buy or sell stocks by betting on the stock's future value without actually buying the stock. This is usually just called an option. This financial device is not what people usually refer to as a stock option in a divorce. These types of stock options usually only last for a short period of time. Because of the short time frame, these types of independently exercised stock options are never divided in a divorce because the expiration date usually passes before the divorce is finalized. Employment-based stock options. The stock options that are usually subject to division of assets in an Illinois divorce are stock options associated with one party to the divorce's employment. Typically, a company will offer employees the option of buying calls for the stock in the company after a period of time, so long as they still work there. This builds up a lot of loyalty in the employee as they are committed to both staying at the company and making sure the company is successful. The period the employee waits until they can exercise the call is called the vesting period. Until the day the call can be exercised, the options are considered non-vested. If the employee leaves the company with non-vested stock options, those stock options can never be exercised, so they just disappear. If the waiting period expires and the stock options can be exercised, those stock options are considered vested. The employee can exercise those vested stock options anytime, even if they leave the company. How do you divide stock options in an Illinois divorce? It just isn't fair to say that non-vested stock options have no value. If the employee just keeps working at the company, those options will eventually have value. Illinois used to have a bunch of convoluted court rules for how to best distribute both vested and non-vested stock options. Now, Illinois has a statute that says that it doesn't matter if a stock option is worthless today, and it's still a marital asset like anything else that was earned during the marriage. If a stock option is somehow premaritally earned, a gift, or an inheritance, then the stock option is not divisible in an Illinois. The statute openly acknowledges that no one knows what stock options are worth, and the two parties will have to wait to determine the value and distribution of a stock option. How can I get my share of the stock options when they're exercised years after my Illinois divorce? Now that the parties are divorced, the non-stock option holding party must rely on the stock option holding party to exercise those stock options and then distribute the proceeds per the parties' marital settlement agreement. The instructions contained in the marital settlement agreement as to how the future value of the stock options shall be handled is referred to as a constructive trust. So, the party with the non-vested stock options becomes the trustee for their ex-spouse's interest in those options until such a day when the stock options can be exercised and distributed. Restricted stock units and divorce in Illinois. Another common employee benefit incentive is to award employees restricted stock units. A restricted stock unit is a form of compensation issued by an employer to an employee in the form of company shares. These restricted stock units are issued through a vesting plan and distribution schedule just like stock options. So, an employee may accrue restricted stock units over time, but the restricted stock units will not turn into actual stock shares until they've vested. The exact same principles are applied regarding restricted stock units and stock options when it comes to dividing these non-vested assets in a divorce. A constructive trust has to be created in the marital settlement agreement. The difference between restricted stock units and stock options are that restricted stock units always turn into the stock of the company after completely vesting. That stock in the company is going to have some value unless the company goes bankrupt. Stock options, however, may not have any value because if the price of the stock option is higher than the value of the stock option is worthless. Stock options, maintenance and child support in Illinois. Stock options and restricted stock units are not only quasi-assets to be divided in an Illinois divorce, they are also income. Often, an asset cannot be both a distribution of marital assets and income under Illinois divorce law. When a party exercises stock options or restricted stock units, that is a taxable event because it is income at that moment regardless of when it was earned. This implies that stock options and restricted stock units, when exercised, are income. This sudden burst of income may affect the initial calculation of child support and maintenance. A future options exercise or award date may warrant a future modification of the maintenance award from one spouse to another. Are stock options really worth fighting over in a divorce? Stock options have a price. The stock of the company has a price. If the stock option, the right to buy the stock, costs more than the actual stock, the stock option has no value, and therefore you shouldn't fight over it. Moreover, stock options are clearly a real hassle to effectively divide and distribute. Ex-spouses will have to deal with each other for years as they slowly exercise and divide stock options. In lieu of dividing stock options in an Illinois divorce, parties should consider awarding something a relatively similar value in lieu of the stock options. Stock options, by their nature, have an uncertain value, so the determination of what marital assets to allocate it in lieu of stock options will be inherently uncertain as well. If you'd like to learn more about stock options, restricted stock units, and Illinois divorce laws, contact the law office of Russell D. Knight today at 773-334-6311 to discuss your matter in a free consultation.